Hey everybody, John Skiba here, and in this video, I'm going to teach you how to do opening statements and closing arguments in your debt collection trial like a pro, so the judge thinks you've been doing this all your life. But if this is your first time here to my YouTube channel, go ahead and click subscribe. That way you'll get notified each and every week when we put out new videos that help you deal with your serious debt problems. All right, in this video, I want to share some more trial tactics and strategies and approaches. Now, I know that a lot of the concern or anxiety that a lot of people have when they get sued with a collection lawsuit is that thought of going to trial, particularly without an attorney. You're not knowing what you should do. You're not knowing the process. I found that if you know some of the little nuances that when it comes to doing trial work and going to court, it can make the whole thing a lot less scary, reduce the stress. You'll start getting sleep again at night, and it'll even help you to have more credibility when you get before the judge. That can help you win your case. So when you go to trial, when you're the actual trial or the debt buyer or the debt collector or the creditor, whoever it is that's suing you, when they're actually there, they have to present their case. You're going to have a chance to cross-examine their witnesses. You're going to be presenting evidence. The format for the trial will be, the whole thing will start with what are called opening statements. This is whether you have a jury, whether you have just a judge, what we call a bench trial. You're going to get a chance to provide an opening statement. The plaintiff always goes first. So the debt collector is going to go first with their opening statement, and then you're going to get an opportunity to provide an opening statement after that. Depending on the local procedures of your court, the plaintiff may get to offer some additional information, but usually it's just their opening statement and then your opening statement, and then the plaintiff will go and present their case to the court. They'll call their witnesses, you'll have a chance to cross-examine their witnesses, and then often they will rest, meaning they're done with their case, that they're not going to present any more witnesses, no more evidence, documents, nothing like that. Then it's your turn. And then you will call any witnesses you may have. You'll present any evidence to the court that you may be wanting to introduce. And then at the end of that, you will close your case. You'll rest. Then the court will ask the parties to provide closing arguments. The debt collector's attorney will go first because they're the plaintiff. So they will provide their closing argument. You will then be given the opportunity to provide closing argument. And then the plaintiff will get the last say. They will get to offer some reply as far as their arguments go. So in this video, I want to focus specifically on the opening statement, what that is, how it should be formatted, and the closing argument and what that is. Sometimes people think these aren't important, but really the opening statement kind of lays a roadmap for the court as far as where you're going to go with your defenses. And then the closing argument just ties it all together and allows you to really plead your case before the court as far as why you should prevail in the debt collection lawsuit. So let's talk about opening statements. Opening statements, one, they're not closing arguments. And what I mean by that is that it is not your time to argue your case. It's not your time to present arguments as far as to why you don't believe that you should be held liable. It's your time to, like I said, lay the roadmap for the court of where you're going to go with your defense. So the plaintiff is likely to get up there and say that the evidence will show that an account was opened on this date, that it was transferred to portfolio recovery on this date. The evidence will show that this is the dollar amount owed and that that we're entitled to a judgment. You can get up there and say something similar. You can say, hey, the evidence is going to show that I never entered into an account with portfolio recovery. The evidence will show that portfolio recovery never loaned me any money. And the evidence is going to show that my specific account was not transferred between these various entities. Something simple like that. You're really just kind of pointing the court to the different areas you're going to go as far as your defenses are. It can be relatively short. In cases like this that are often heard either in the small claims or like in Arizona where I practice there, most of them are in the justice court. The opening statement is usually just 3 to 5 minutes each. It's just really an opportunity to let the court know and give them a preview of what you anticipate the evidence is going to show that you're going to present as far as your defense to any of the claims of the plaintiff. Now, closing argument, which happens again after all the evidence has been introduced, all the testimony has been given by the witnesses. This is time for you to be an advocate for yourself. You can draw inferences. You can just flat out argue your position. You can argue the justness of your position. You can kind of just let loose when it comes to closing argument. This is your time to persuade the court. You can try to connect all the dots or the lack of dots when it comes to debt collection cases as far as the lack of information that they have. This is your time to persuade the judge or the jury, however your trial is being heard, that you should prevail in the case. This isn't just merely a roadmap. You can draw inferences. You can pull things together that maybe the other side disagrees with, but you can still pull them together and argue why it is the court should argue or should rule in your favor. So I hope that that's helpful of understanding the opening statement and the closing argument. If you do those correctly, if you don't include argument in your opening statement, and the opening statement is not your argument, this is where you can just let loose and let the court know why it is that you should prevail in your case. This will show the court that you're taking this seriously, that you're more fully prepared, and that you're doing the procedure correctly when you get before the court. That can not only reduce your anxiety, but can help you go a long way for winning your case. Thanks for watching today.